today, aiding your success using AI in the workplace. Joining us for this session are my colleagues Matthew Anderson and Preston Ball. Matt is a partner in the Labor, Employment, and Immigration section. He's based out of our Richmond office, and he is an experienced corporate employment attorney with a particular focus on defending businesses in employment litigation matters. In addition, Matt represents companies and insurers in employee benefits claims litigations under ERISA. Matt also advises clients on compliance with employment laws and regulations such as Title VII, the Family and Medical Leave Act, the Fair Labor Standards Act, the Americans with Disabilities Act, and the Age Discrimination in Employment Act, as well as providing general employment guidance and counseling to businesses on human resources best practices. Preston is an associate in our Williams-Mullen Labor, Employment, and Immigration section and is based in our Virginia Beach office. He focuses his practice on labor and employment matters, advising clients on federal and state employment laws and regulations such as Title VII of the Civil Rights Act and the Age Discrimination in Employment Act, the Fair Labor Standards Act, Family Medical Leave Act, and the Americans with Disabilities Act, as well as National Labor Relations Act and Virginia employment laws. So many acts that they're advising on. So with that, I will hand it over to my colleagues. Matt, please take it away.
Thanks, Julia, for that introduction. I'm going to kind of vamp here for just a few seconds to give anyone who had to switch over from a mobile device onto a desktop or a laptop some time because we're going to hit you with the polling questions right out of the gate on this one. If you could, I'll go over our agenda to kind of fill that space. We're going to start off with the benefits of using AI in the hiring practice or in hiring. Then we're going to talk about the dangers of doing that. We'll look at recent trends in the use of AI. We'll look at the new state laws on AI, and we just had something come across the other day that is not going to have a slide on it, but we'll touch briefly on that when the time comes. We'll talk about the EEOC guidance that was put out under the Biden administration, but has now been pulled back because it's still good guidance for employees, even though it may not be enforced by the EEOC. Then we'll talk about risk management and things to avoid, and wrap it up with kind of a general takeaway of what AI in the workplace is looking like these days. All right, so for our first poll, we just want to get a temperature of do you use AI on a regular weekly basis as part of your job, just so we can get a sense of who here in the audience is using AI. All right, that's a 60-40 split for no. That's not that surprising to me. Lawyers tend to be kind of late adopters to things, particularly given the thorny ethical issues that we're seeing. And we'll talk about some of the problems the early adopters in the field of law have come into in just a few minutes. All right, next poll question, please. For those of you who do use AI, what do you use it for? The options here are: do you use it to help draft documents, help you do your research? Do you use it to take care of administrative tasks, or do you use it in hiring, firing, vetting potential employees of your firm or even your client's firm to the extent you might be involved in that process for a client?
And if you're in that 61% of folks that doesn't use AI regularly, pick which option you think you would most like to use AI.
Okay, so research. Okay, that also is not surprising to me. And we'll talk about how that best fits into the practice of law coming up here. And we got one more polling question. Preston, I believe this is for you.
Yeah, so which AI platforms do you use the most? Again, if you're in that group of folks that isn't using AI, choose that last option, none of the above. But um, if you are using AI, hopefully we've got one that you use here: OpenAI, ChatGPT, Anthropic, Microsoft Copilot, or Google Gemini.
And remember, you have to answer all of these polling questions to get credit for attending. All right,
Okay.
ChatGPT. That yeah.
Yeah, that makes sense. Most of you guys are using OpenAI platforms. So, um,
All right, let's go on to the next slide, please. So we'll talk about the benefits of using AI in hiring. Um, a lot of these, there are a number of providers that provide AI assisted hiring services, and I use hiring briefly, broadly to include not only hiring but promotion as well, and probably even termination. But these providers use machine learning to kind of cull through all your applicants, read their applications, their resumes, etc., for you, link it up with kind of the job descriptions and qualifications, and kind of kick out anyone who the AI doesn't think is a good candidate for the position, and gives you a list of here's the people the AI thinks would be right for this position. Um, that obviously saves the hiring manager or whoever's in charge of doing that legwork a lot of time, depending on how many applicants for a position you got. If you've got hundreds and hundreds of applicants for a position because you've posted it on LinkedIn and you use the easy apply, and people just have to click one button and they apply, and don't really have to think about, am I qualified or not? This is a quick way to get those applicants out of your hopper, and only deal with the ones that are qualified. Saves time. Time is money. Uh, and if you've got a good AI, it's got the potential for truly identifying good candidates, so you don't make a hire that 90 days later you regret. Next slide, please. But there are dangers of doing this, because like most things, AI is only as good as the person using it. And It's not a perfect art right now. It's not a perfect science right now. They AI platforms have been known to create fake information, fake images, fake news, and lawyers are just as susceptible to this as anyone.
And,
Um,
and before we move on to the next slide, Matt, I'll jump in here and say, obviously, 61% of the folks attending today said they didn't use AI on a weekly basis. And I would posit the question to everyone, are you sure? A lot of websites you may use, whether that's LinkedIn, other third-party vendors, may be using AI and not telling you. And so I think we just need to be aware of that as we go forward here. Next slide, please. So I'm going to give a little background on something that happened to me recently. I was involved in a case in federal court here in Norfolk, and I was preparing for a hearing, and I was pulling and downloading all the cases that the opposing side had cited. And in that instance, I couldn't find a particular case. And the case that appeared to be cited was United States versus Parla, as you see on the screen. Well, it turns out that case did not exist. And so we actually had a hearing. I went into the hearing and told the federal judge that the case didn't exist. And for a while, the federal court did nothing. And then a few weeks later, after that particular motion had been disposed of, we got a notification, and the court was going to have a hearing, a show cause hearing, to determine whether or not that particular attorney who cited that fake case was going to be sanctioned. And so that hearing actually happened almost a month ago now. And so here's what the court said. It said the court could not find any captioned case, United States versus Parla, nor could it find any case in which the quoted language was used. Additionally, the reported citation is actually a 10th Circuit case, Mangles versus Pina, which is wholly unrelated to the proposition which counsel cited it for. So next slide, please. Now, under Federal Rule 11, the court determined that the only reason that somebody would cite a fake case was because of artificial intelligence. And the court has this little parenthetical citation here talking about a case actually out of the Richmond division where about 40 citations in the Powhatan County School Board versus Skinger case, there were about 40 citations and the court fake citations, and the court issued an opinion and sort of coined the phrase here in the Eastern District of Virginia, AI hallucinations. And so what ended up happening in this case is we had a hearing, and the judge grilled the other lawyer for about half an hour. Ultimately, the court said one instance of citing to a fake AI case is not going to be sanctioned. And so the court ruled that it was incidental. It didn't end up prejudicing the parties. And so despite the fact that this other lawyer had cited a fake case, the court did not sanction them. And there was an interesting takeaway in that case. The lawyer on the other side who did cite the fake case actually said to the judge, he said, "I'm never going to use AI again." And the judge looked at him and he said to this lawyer, "I think there's going to come a time where AI is so prevalent in the practice of law that we're all going to use it. And so I'm not sure you can tell the court that you're never going to use AI again, but there will likely be some regulations coming out." And so I use that to illustrate the fact that 61% of our viewers are not yet using AI. There is going to come a time where you use AI in your work, whether that's doing research, doing hiring and firing. That time is coming, whether we like it or not. And so I'm not necessarily advocating for that in this moment, but what I am saying is that those things are coming. And so what we want to do today is give you some guidance on how to do so appropriately when you actually get to using AI, because I think it's going to happen in the next few years for those of you who aren't already. Next slide, please.
I think before we jump to the next slide, we can talk a little bit about some other instances where these hallucinations have caused problems for attorneys. I just did some quick research the other day, and I found a case where a federal judge dismissed 3 lawyers entirely from the case. They said, because of your use of citing AI hallucinations, you can no longer litigate this case. So that put their client in quite a bind of trying to find some new lawyers. I found some. Yeah, go ahead.
I believe that case was out of one of the districts in Alabama, and in that opinion, there's a particularly poignant line from the court which said, if fines alone were enough to deter lawyers from using AI, I wouldn't have so many cases to cite of lawyers using AI. I thought that was a really interesting line from the federal judge in that case.
Yeah. And fines are kind of the penalty du jour. I found $2,000 fine out of Massachusetts for AI citing AI hallucinations, $5,000 fine for citing eight AI hallucinations, $5,500 fine. But the most interesting or I think egregious penalty, not egregious, but harshest penalty I could find was a judge in the Middle District of Florida banned an attorney from practicing in that court for an entire year because that attorney cited 26 fake cases over four different pleadings. And so the court issued a sanction saying you are barred from practicing this court for a year and you have to reapply for reinstatement. So it's possible that bar extends beyond a year. Um, I think it's important that, it's standard practice for us sometimes to, you're supposed to pull every case that your opponent cites. And, sometimes with all the work we have and the quick deadlines for some of these briefs, we just don't have time to do that. And we just kind of, take it at face value and assume our opponent is citing case law correctly. But I think that at this day and age, I mean, the last two briefs that I have filed responses to in the last month have contained cases where opposing counsel has, I wouldn't say cited a fake case, but cited a case for a proposition that just doesn't exist in the case. Like the words that they quote don't appear in the case at all. And so there wasn't enough there to go to the judge and say they're using AI to generate these things, but it was enough where we called it out and we'll kind of let the court make their own decision as to why every single case they cited doesn't stand for what it meant. And I learned this week that there's a website where you can submit your opponent's briefs and it will check to see if it has been AI used in creating that briefs, which to me kind of seems like the snake eating its own tail of using AI to detect AI. But those are out there. I'm sure you can find them if you want to use them. Um,
Yeah. And Matt, one thing that I worry about personally is, I'm local counsel on a lot of cases in the Eastern District of Virginia where our firm is not necessarily writing the briefs. Another firm from another part of the country is writing the briefs. And ultimately, at least under the local rules in the Eastern District of Virginia, they're going to hold the local counsel responsible for that, even if you're not lead counsel. And so I have qualms a lot of times about briefs and that I might be local counsel on didn't draft that might have used AI in those things. So that for me personally, that's my biggest area of concern.
Yeah. And I know that Westlaw and Lexis do have AI tools built into their systems where at the very least you can drop a brief in and it will flag, incorrect citations. Now, it's not perfect. I used it a couple weeks ago and it called out things as being incorrect citations where I had paraphrased instead of direct quoting. So, take that as you will. All right, so let's move on to new state laws. Illinois, not surprisingly, is one of the leaders in this space. It was House Bill 3773, but it has been codified as 775 Illinois compiled statute 5/2-102L. Um, and this, I think, is going to be kind of a blueprint for a lot of states. It bans discrimination resulting from the use of AI. Um, I'm not sure we need a ban on that because discrimination is illegal in whatever form. it takes, whether it's you personally deciding you don't like someone because of their protected characteristic, or if it's your computer deciding that they don't like someone because of their protected characteristic. Um, but that's they put it in writing. Your AI, you can't use an AI that discriminates in the employment space, and you have to provide notice to employees and applicants that you are using some sort of AI program as part of a screening method, whether it be for hiring, promotions, firings. It's very basic. The one thing I will note is that it does say in the statute itself that you can't use AI in hiring, promotion, renewal of employment, selection for training or apprenticeship, discharge, discipline, tenure, or terms and conditions of employment. If the AI creates discrimination on the basis of a protected class, and you cannot use zip codes as a stand-in for protected class. I thought that's the first time I've ever seen something like that, and I think that I'd like to get the story behind why, because that seems like a very specific something happened, and so the legislature is taking specific action to correct that.
That's
Preston?
interesting, Matt.
Yep, go ahead.
Uh, I'm just going to touch a little bit on the Colorado AI Act. And so, as I talk about the Colorado AI Act, this is probably the most aggressive state law that I've seen. And so, it's not yet in effect, but it'll go into effect soon. But it has been passed. And so, it actually defines what's called algorithmic. Um, Discrimination, and it places the burden on AI developers to create products which prevent that discrimination. And so I think that's really interesting. A lot of the concerns that I have for clients and you know individuals alike is employers being responsible, but the AI Act says no. Developers beware. We are going to put you on notice that you may be liable for discrimination caused by a program you create. Now, I don't think that necessarily takes employers off the hook, but it certainly does make developers very aware. Now, I want to touch beyond that. Obviously, I practice in the Commonwealth of Virginia. And so during the 2025 session of the General Assembly, the Virginia General Assembly passed a bill, Virginia House Bill 2094. And what House Bill 2094 did is it looked a lot like the Colorado AI Act, and it targeted and regulated developers who were developing AI programs that were for high risk purposes. And one of those purposes includes using it for employment. And that bill passed this January from the General Assembly and then passed both the House and the Senate. That bill went to Governor Glenn Youngkin's desk. On March the 24th, 2025, he vetoed that bill. And so that bill is not going to become good law. It was not overridden by the General Assembly, but it looked a whole lot like the Colorado AI Act in that it targeted those developers.
And yeah, I was gonna flag this later in our discussion, but I think that it's important to note that because every year is an election year in Virginia, we've currently got an election for the entire General Assembly and the governorship going on right now. And so, the way things are looking, it looks like that the governorship there's a good possibility that the governorship will flip over to Democrat control, and they'll have the trifecta. So don't think that this initial bill that was passed with some bipartisan support is going to go away. And if something like it comes up again next year in the session, I think there's a good chance there's going to be a friendlier governor that's going to take a look at it. So it might not be the last time we hear this Virginia law.
I think that's absolutely correct, Matt. Next slide, please.
Yeah, this is the New York City local law, which at the time of press was the only law that required employers to audit their AI employment programs. Um, in the code, the NYC code, it refers to these things as automated employment decision tools. And it requires a yearly audit of these tools to make sure that they are not biased. And someone who is much better at accounting and math than I am could probably read the statute and understand exactly what it is saying, but the best I can, what I make of it is that you kind of have to look at uh, percentages of when of selection, and you have to look at impact of these tools on selection of sex and selection of race and ethnicity, and then the intersection of the two. So you have to compare what's called the impact ratio of, for example, Hispanic males versus non-Hispanic males. And so essentially you're comparing, if 100 white men applied and 50 white men got it, then that's a 50% acceptance rate. And then you compare that to, all right, if 100 Hispanic men applied and only 30 of them were selected by this tool, then that rate is obviously 30%. You compare 50 to 30, and if there are significant deviations from that, your AI hiring tool is discriminatory. And so you not only have to perform this before you even implement it, so you have to essentially do a trial run with kind of made up, you know, numbers to make sure, that mimic kind of what your hiring pool looks like. So that it's good before you start using it. You have to an audit has to be performed within a year, every year. And you have to post this audit somewhere that is publicly available. Um, well, let me back up. Sorry. When you start using a new tool, you can use historical data from other employers or a test set data, a test data set. But yeah, so you have to post your audit every year, make it publicly available so applicants and employees can go and look and see and make their decisions as to whether they think that your AI hiring tool is good or not. And you have to notify employees and applicants that you're using the tool, like the Illinois law. Um, and you have to kind of explain to them, all right, this is the information that we're putting into this to make our decisions. And you have to do that 10 days before you put their information in. And they're allowed to opt out, if I remember correctly. Um,
Matt, I think
yeah.
one thing that's really interesting to me about this law, and I'd love to get your thoughts on it. Um, let's say you're an employer and you abide by the New York City local law, you do your third party audit, you post your summary of your audit, you give employees the opportunity to opt out, somebody opts in, they don't get the job and they sue you for Title VII discrimination. Do you think this is going to be a type of thing, maybe on summary judgment, you're going to put evidence that you use this program that wasn't discriminating? How do you know you used an audit? Do you think employers might be able to use that to help defeat some of these discrimination claims on summary judgment?
I think you would, and put a pin in that thought because once we kind of wrap up with this, I want to revisit that based on some news that came out earlier this week. Just kind of wrapping up the New York law, there are fines if you are using a non-compliant AI hiring tool. Um, it's $500 for the first violation and every violation that occurs that day, and then every subsequent violation it can be between $500 and $1,500 for any subsequent violations. And every day that you use it, it creates a new violation. So these penalties, if you're a high volume employer, these penalties can really start to stack up because if you forget your audit and it doesn't get posted, and you've got a week between when it was supposed to be and when it wasn't, and you've got, you know, 1,500 people applied to various jobs you have posted in the city, that can really add up quickly. Circling back to using the audits as evidence, this week, California issued its regulations regarding the use of AI in employment. And It did not explicitly require an audit, but these regulations do say that the presence or absence of an audit will be looked at as evidence of indiscrimination claims. So having an audit and one that supports your position that the AI was not discriminatory in California, great thing. If you don't have it in California, that's probably a bad thing. Because my guess is that those who are enforcing this law, whether it be from a state agency or a PAGA action, or an employee who is claiming discrimination, they'll jump on that because they've got this regulation now that says the absence of an audit can be used against you. And so, this is kind of a backdoor audit requirement. So now we've got New York City and all of California where the law at least strongly encourages you to audit your AI hiring tools. Next slide, please.
Okay, so sort of the seminal case around the nation right now having to do with AI hiring, AI discrimination in the workplace is Mobley versus Workday. And you can see the citation there on the screen. So in this case, Workday, as many of you know, is a HR management service. And so it does a wide variety of services for employers. One of which is it uses a platform for employers to collect, process, and screen job applications. But it also uses AI to do so. And that's where this case heats up. So Workday was using this software. It was filtering applicants for a wide array of jobs and a wide array of applicants. And one of those applicants was the plaintiff in this case, Derek Mobley. And Derek Mobley is an African-American male. He has a bachelor's degree and a graduate IT degree and was doing some contract IT work. He used Workday's software to apply to over 100 jobs. Each one he was denied from. He didn't get a single job from those 100 applications. A few examples that are particularly egregious in this case is at the time he was applying, he was doing work for Hewlett Packard as a contract worker, IT worker. He then applied to the equivalent position in-house at Hewlett Packard and was rejected a month later. So he's doing the same work for the same company, applies to the in-house job, and then was rejected. On another occasion with a different company, he was rejected in 55 minutes by this software. And so he filed a lawsuit against Workday, not against each individual company, but against Workday, and said, Workday, I know you weren't the employer, but you were an agent of the employer. And I'm under an agency theory of liability. You're liable under Title VII, under the Americans with Disabilities Act, and under the Age Discrimination Act. And so that is really significant because this is the first time, at least that I'm aware in the federal court system, where there has been a large lawsuit brought against a vendor, not an employer, for using and developing AI. Matt, do you want to talk about what the court found in this case?
think this case was kind of teed up for the court to make the ruling that it did because, as you mentioned, Mr. Mobley was African American man over 40. He had documented anxiety and depression, and in the complaint, he lays out, look, here's my experience. Here's what I was doing. Here's my experience. Here's how here was the process. Every time I went to an employer who used Workday, I had to log into their Workday site and create an account and upload my resume. And almost every single one required me to take some personality assessment. And that personality assessment almost certainly was able to pick up on the fact that I have anxiety and depression. And so that's why he got the trifecta of, you got race discrimination, age discrimination, and disability discrimination. Workday claimed, look, we were just hired by these companies. It's on them. They're the ones not hiring this man. We just provided them with service, and the court said no. That you don't get out of jail free here. A lot of the writing and the opinion was on Title VII, but it essentially said the language of Title VII for holding employers liable for discrimination includes third parties to whom employers give these HR functions to, and so by dint of the fact that HP and these other employers that were using Workday essentially turned over the keys of at least the initial hiring process to Workday, meant that Workday became, for all intents and purposes, an agent of the employer, and therefore shared in that liability.
Matt, there's a particular line from this opinion that really
Mhm.
stood out to me. And it says, drawing an artificial distinction between AI decision makers and human decision makers would potentially gut anti-discrimination laws in the modern era. And I think that's remarkably poignant. And it says basically, if you're a software developer, it doesn't matter. You're just the same as a human decision maker.
Yeah, and I was going to flag that. That Workday did argue, look, there's no discrimination here because it's all automated, and they said, what difference does that make? And so this is at the motion to dismiss phase. The court found that the disparate impact claims survived. It did grant the motion to dismiss on the intentional discrimination claims because there was no. Mobley didn't make any allegations as to some specific act that showed intention that these tools were going to be discriminatory. And so this case continues on, I believe.
It's a class action suit, and so I believe this past summer, it was actually it received preliminary class certification in this case. So it's still ongoing. I'm sure it'll be another year before we find out the outcome, but it should be very interesting, worth keeping
Yeah.
an eye.
But I think the takeaway here is that, you know, yes, these AI vendors can be held liable, but it does not absolve, and the decision in no way absolves the end client of any liability. It just said, hey, you as the agent share liability. In this scenario, Mobley didn't sue the end employers because I mean, to me it makes litigation sense. Let's find the common denominator here, bring a class so we can fold in all of these people who've applied to all these different jobs that go to these end clients instead of trying to bring lawsuits against every end client, because each one would probably have to be an individual lawsuit. Maybe you get them consolidated into one case, but that probably would have been a something that a court would not be too keen on, given how widespread Workday is. I mean, I know that 5 or 6 years ago, when I was looking for jobs, it seemed like everyone was using Workday already. So, um, I think just because Workday was liable doesn't mean you are not liable because if you use Workday. Um,
Yeah, and if we could jump to the next slide, I'll touch on that a little further. Yeah, so this is a quote from the U.S. Supreme Court, but and it is an older quote, but it says that employers cannot escape liability for discriminating by delegating their traditional functions, like hiring, to a third party. I think that's still good law. And if you do that, even if it's AI or it's a consulting group, what have you, the employer at the end of the day can absolutely be liable. They may not have been in the Workday case, but they could be in your case.
All right. Next slide, please. All right. The EEOC guidance. Um, May it rest in peace. In 2023, under the Biden administration, the EEOC issued guidance on the use of AI in the workplace, and it came in two forms. They had a Title VII guidance and an ADA guidance, and they are generally the same. And honestly, if you pull these up and read them, I don't think that they were breaking any ground. It just explicitly required employers to use AI selection tools as they would any other selection process. And that the 1978 guidance on this on selection processes applies to AI use. And so, kind of echoing that New York City law, the EEOC said, you as an employer have to make routine assessments as to whether your AI is having an adverse impact on protected groups, and that you will be responsible for any discrimination by your AI tools, even if they were designed by third parties. It re-emphasized it's called the 4/5 rule, which if the selection rate is less than 80% between two groups, that is a substantial difference. But that 4/5 rule is a rule of thumb. It may not be applicable in all cases. And then, the other where the ADA guidance went further, is there are reasonable accommodations to be considered when using AI. It's a failure to provide a reasonable accommodation if an applicant is not treated fairly by the algorithm. If an algorithm screens out disabilities because of an assessment isn't accurate due to the impact of a disability, that's a problem. And so um, employers need to be aware that, if you've got some sort of assessment and an employee has a disability that may affect the ability to take that assessment, you've got to offer a reasonable accommodation so that this AI tool doesn't just disqualify them out of hat. Um, the standard for the ADA is to perform the essential functions of the job with or without a reasonable accommodation, and so that's going to apply when using AI as well. But
I think
go
I think
ahead.
it's worth mentioning here, just because the Trump administration has taken that guidance down, doesn't mean that the federal courts, are not going to find employers liable for use of AI programs. I mean, this is just guidance from the EEOC.
Mhm.
And so the Trump administration, by taking that down, has not really at all affected the law of the land.
Right. Yeah. And yeah, the Trump administration's reasoning for pulling this guidance was they wanted to unshackle AI developers and make the United States the leader in AI. I mean, to the extent we already weren't, we already were. But, like Preston said, this doesn't change the fact that Title VII, the ADA, the ADEA, they all still exist. And like a lot of these Trump administrative decisions, they may proclaim one thing, but it doesn't change the fundamental law of the land, particularly as it pertains to discrimination. Um, so it's certainly something to keep in mind that, that's why I say looking at these EEOC guidance, even though it's not good guidance anymore, the EEOC is not going to enforce it anymore. It's still excellent as far as helping clients navigate using AI in the hiring process. So,
Great.
yep.
Next slide. Okay, so here I have a little cutout, and I know it's kind of bulky on the screen, but this was part of the guidance, particularly as to old guidance under the Biden administration, but guidance as to Title VII, determining whether an employer is responsible. And the EEOC says point blank that yes, employers who use AI programs may be liable even if that program was developed by an outside vendor. And so, I think this guidance reaffirms what we already knew and what the case law already said, but it's worth reiterating. Employers will be liable for the acts of a hiring agent, whether that's AI or whether that's an actual human being.
Next slide, please. So, how do we avoid discrimination while still using the AI? Um, you know, I boiled it down to kind of three bullet points. You got to the best practice now. Notify people. Let them know you're using AI. I know it's not required by every state, but I think it's good practice because, if you look at the ADA guidance, if you let someone know, hey, we're using an assessment that will be analyzed by AI, that's when they can raise their hand and say, I need an accommodation. And you just bought yourself some grace there. Train your people who are going to be using AI to train them what to look for, train them on inputs, etc. And then audit, audit, audit. I know New York is the only one that's explicitly requires an audit. California now has the backdoor audit, but audit your systems. Constantly look at them. And so, and as you see here on the screen, if you're going to hire someone to provide you with that AI, do your research, find out, talk to them, go get under the hood, figure things out, don't be shy, because, while the Workday case is out there, holding Workday liable, that's one federal court, federal district court. It's not setting the law of the land here. And it again doesn't erase employer liability for those third party tools. So make sure you know what you're dealing with. And if you realize your tool is discriminating, fix it as fast as possible.
Matt, I would predict that a lot of those 100 employers that Mr. Mobley actually applied to, I bet a number of them didn't even know that Workday was using AI. So that's a warning to all of us, I think.
That wouldn't surprise me either.
So next slide, please. So just want to go through a couple of takeaways. You want to pay attention to industry specific requirements for AI. Depending on what industry you're in, there are going to be different requirements. Scope of permissible uses for employees is also going to be critical. And along with that, scope of employees who are authorized to use AI. I think those go hand in hand. What are you going to allow your employees to do with AI? And who are you going to allow to do those things, I think is really important. There might be certain things that are just too risky to allow every single employee to have access to that platform. Perhaps that's open AI platforms. I think that most employees should not be using open AI platforms. And just so we all know, when I talk about open AI, I'm talking about ChatGPT. And ChatGPT filters its information from everywhere. So you put confidential information into ChatGPT, it's not necessarily confidential anymore. And I think that leads into data security risk management. If you're putting confidential information into AI, you better be aware of whether that's open AI or a closed system, and it needs to be in a closed system. If not, when your competitor searches Chat GPT about a similar issue, it's going to use the information that you actually put in there to give them their answer. And so you have potential confidentiality breach issues with that. I also think training your employees on AI, know the standards, know what, you need employees to know what you expect of them. That's really important. And then finally, supervision and compliance. It's not enough to just train your employees. You need to make sure on a regular basis people are following the policy. Because if not, you're going to start to wander astray and you might end up being the subject of one of these lawsuits or defending one of these lawsuits for your clients.
Yeah. And, a lot of our talk today has been on how are you using AI in the hiring and promotion firing space. But, you may decide there's too much risk in using one of those AIs in that space, but we still want our what are your employees using generative AI, AI to generate work product in kind of their other, the non-HR functions. And it's really important to have a good policy there, like Preston touched on. You got to have policies making sure that you're compliant, you're keeping your trade secrets, you're keeping your confidentiality, your confidential information confidential. You're not violating IP laws. You're protecting your IP. You want to me, it's best practice of, if you're going to have employees using generative AI, spell out these are the generative AI resources you are allowed to use. These are the ones you are not allowed to use. They need to be aware that, hey, you have to double check everything that this AI spits out, because we don't want to, present a client with work product that has hallucinations all through it. And lastly, I think I think it's best practice to, if your employees are going to be using generative AI, they need to save their prompts that they put into that AI. I've drafted a policy for an employer on this issue, and I created a form that if the employees are required, if they are using AI to create something, they have to put into that form what they inputted into the AI to get that result. And it goes with that work product. And that way, if there's ever any sort of question about anything, whether it be litigation, workplace investigation, an angry client, you will have that look. This is what we put in, and this is what we got out. And that will help you get to the bottom of, if something's gone wrong, what has gone wrong. Um, so that's just, you creating policies in the non, HR function space. So next slide, please.
Okay, so just real quick, want to run through the takeaways from our discussion today. First and foremost, create an AI hiring guidance policy. And if you're not using AI in hiring, create an AI policy. Make sure everybody gets a copy of that policy, disseminate that so everybody knows what the expectations are for them. Conduct regular AI audits. I think that's really critical if you're going to use AI on a widespread basis, whether that's in hiring. Do those audits. I think those audits are going to be potential evidence that works in employers' favor when you get to the summary judgment stage in federal court. Also, changing policies. I think there's a strong argument to be made if you do an audit, you see the results aren't what you expected, actually getting that vendor to change that algorithm, I think really will work in the employer's favor. Human oversight. As AI becomes more prevalent in our society, there's going to be no substitute for human oversight. Humans are the ones who know right from wrong, and so I really think that the most amount of human oversight is going to really benefit you in the long run. And then finally, provide choices and opt-outs for applicants if you're going to use AI in hiring. Give them that option. If they don't want, to be screened by AI, I don't think you can force them to be. So with that, that covers our presentation for today. So we're going to go into question and answer in the very brief few minutes we have remaining. So Matt, I'm just going to ask you a question as we start. How do you expect those AI laws to continue to evolve on the federal level or on a state level?
I think it's interesting you asked about federal law this week when our federal government can't even stay open. Um, I would be surprised in the next 3.5 years if there's any movement on the federal level, simply because the Trump administration's position is that we don't want to put any sort of restraint on AI because we want it wide open. And they've also shown that they don't really care about discrimination unless someone asks them to, tackle AI from a reverse discrimination standpoint. I don't think that the federal government's really going to be making any significant inroads on that point. So I think that it's going to be state law. Um, I think the Illinois law is pretty reasonable. Um, Make sure it's not discriminating and tell people it's happening. I think that that's going to eventually kind of become what we see elsewhere. And then I think they're going to be kind of the outliers like California, Colorado, possibly Virginia, where it's a lot more stringent and requires a lot more diligence on the part of those using AI. The Virginia law that was passed and vetoed actually expanded beyond the employment realm. So, you know, I think that there will be laws like that. Speaking of Virginia, Preston, you have anything? I know we touched on it earlier, but do you have anything to add on Virginia laws and AI?
Yeah, Matt, I fully expect in the next General Assembly session in 2026, there will be an AI bill that's put on the governor's desk. What that bill looks like, I think, as we touched on earlier, depends on who's in that governor's chair. And I think maybe more importantly that it matters what happens down ballot a little bit, who's going to be writing that law. Um, you might see it be a little bit less aggressive than the version that was passed in 2025, but it could be a very similar version. But I would fully expect that law will be on the governor's desk in March.
Yeah, I agree.
Matt, I know we're almost out of time, but do you expect plaintiffs or you know plaintiffs' lawyers to target developers or employers as this moves forward?
I'm going to give the best lawyer answer ever. I think it depends. If it's a situation like Mobley where it makes more sense and the bigger payday is by going after the developer because you can by proxy bring in all these different employers that these people have applied to jobs. I think it would make sense. Plaintiffs attorneys are going to go after a workday type. But for a class action, but on in an individual basis, I think you'll probably see kind of an even spread. Co-defendants, if you will, or rather than trying to wrangle any sort of jurisdictional questions, they'll just say, hey, the people I applied for whose office is down the street from me, whose AI discriminated against me, I'll sue them. If it's here in Virginia, for example, and you and a plaintiff's attorney can see, hey, look, I can use the state laws to get after the discrimination here. That way, I don't have to worry about summary judgment, and I can take this thing to the goal line. You might see more of going after just the employers, but I don't think plaintiffs' attorneys are going to be, selective in saying we're going to go after one or the other.
Awesome. Well, it looks like we're out of time. If you asked a question that we did not get to today, we'll reach out to you after the program to follow up with you directly. Thank you for joining.